What's up, everyone? It's 2 p.m. on a Wednesday afternoon, which means you're tuning in to Cannabis Legalization News. I'm producer Lauren, and today we're going to be speaking with Scott Roberts from Scott Roberts Law out of Michigan. Applications start on November 1st, which is in 2 days, so we're going to be talking about Michigan's cannabis landscape in a few minutes. But first, we do have to get into a little bit of cannabis legalization news. So what's going on in the news this week, Miggy and Tom?
They basically decided to take a huge dump on the emerging hemp industry. And by they, I mean Sonny Perdue and the boys over at the USDA. Let me bring up my screen so I can share it real quick. And application window is the only way to go really on that. There you go. Do that and hit share. And this is going to be our guest, so do stay tuned to him. But this came out yesterday. It's 160 pages. And the big thing that you can always do now, because it's the future, you just hit Command F and then you can find something. And that's not incubator. What you really need to look for is total THC in this. And it appears 8 times in the new hemp bill that we have. The thing about that is it's going to be really, really strange in the sense that that's not what it says. Like, you know, the statute doesn't say shit about total THC. It says stuff about
THC 9, right? Delta 9?
Yeah, Delta 9, right. It's supposed to say stuff about Delta 9. And then if you, I don't know, I'm trying to also manage I should leave Lauren to produce the show and just talk. That's not what the statute says. So, like, you know, I really quickly hopped on the line and then I contacted Rod Kite. And so hopefully Rod, he said he's going to come back on, but now we have to wait for him to get in touch with us because they put out like 5 different pieces over at his law firm. I believe it's, you know, the Kite law firm, cannabis.law, something like that. And they publish all the time. So if you try to find a hemp lawyer, and especially if you're on the East Coast, you're going to find Rod Kite. And we're going to have him here to talk about this 161 pages. The real 2 sticking points that look like it might totally obliterate or just roil the CBD hemp market is the total THC as opposed to just the Delta 9 levels, which is beyond the text, the plain meaning law, like statutory language. And also, you know who gets to test the crop, Miggy?
You talking about the labs? Oh no, it has to be DEA registered.
Yeah, and the DEA has to test it. I mean, talk about that's going to just ruin the crop because the DEA will be like, oh no, we haven't gotten back to it yet. Sorry.
Hey, so how many pages is that?
161, and the term total THC appears 8 times.
Dude, that 161 pages alone tells you why you need a lawyer, and why we can't have nice things.
Jesus. Well, I understand like the highly regulated industry. It's like if you own an airline, you should probably have a lawyer. If you own a cannabis company, you also probably need a lawyer. But you know where you can find one. And we have to give a shout out at the top of the show because we got the shirts.
Oh, yeah.
Yeah. It's the Chicago Normal. And so so we got those shirts. I'll be sending you that one in the mail. I got one for Lauren as well. So remember, it's there. And those people are great. They're really helping out a lot of the social equity applicants, especially in the Chicagoland area. But I'm not so sure about this incubator stuff. You've been hearing about these incubators?
No. You talking about for like the cannabis incubators?
Yeah, man, the cannabis incubators over here in Illinois. And then I'm going to just go ahead and share the screen one more time. And so the incubators, this is in the part of the statute, which of course is the dispensing organization. So you go into the dispensing organizations, Article 15, and then you can very quickly scan anything by using Control Find, and you're going to have the incubator program. Only appears 3 times, and it comes into like whether they want to A, B, or C. How much money are these companies going to pay the state, or are they going to participate in this incubator program? And so if you want your first license, you can do an incubator, and then this one's for your second license. Because you know how they're doing that, right? You heard about how Illinois is doing their first 110 dispensaries?
No, well, it's random, right?
No. Like there's 55 medical dispensaries, so they get it, and they get this option for another one. So that's like 110.
What? So these incubators, because I mean, I know there's a bunch of them that exist as far as like for business purposes. We have one up here. There's a large company from California, Taringo, I think it's called. Anyways, they have a place that I visited one time. That's probably about 5 businesses, all edibles that were based out of this one little building. And I think they get a percentage of the, of course, the company's rights and whatnot. Is that the same thing going on then?
Oh, it probably is, because I mean, they gave them like options to like pay money, or they could do this incubator thing. And this incubator thing allows them to have this wonderful amount of advertising that they're doing, especially in goodwill in the community. So people are going to be more likely to buy Cresco weed, right? It's like, oh yeah, because they helped. And then they do lock you out of the industry a certain amount. Like you can't only hold 10 licenses, but you have to understand, it's not like the 10 dispensaries that are there can not sell Cresco weed. So the more dispensaries that they help get into the door, you're just creating more goodwill. And I get these calls from people that say that they're in this incubator program, and I look and they say everything's free, and I'm like, wait. It makes no sense. How can everything be free? And then you read more in the statute. I'm just like, man, I'm glad that it's there, but be careful about that, man.
So the incubator program for this is actually from the state?
Yeah, it's directly in the state themselves, and it's what you need to do. It's what you need to do to, well, if you don't want to pay, it's one of the ways that you can go about getting your first and second cannabis retail licenses. So it's big, but then if you understand, like, okay, there's there would be 110 of those incubators then, because there's 55 current operating medical licenses, and you double that, you get 110, and there's only 75 licenses that are available this next year. So right there, maybe every single one of the licenses will be one of these incubators. But
that's the barrier that I always talk about, though. I mean, I think that's great. So are equity applicants a big part of that then too?
Huge part of it. I mean, that's really what it's all about. It's all about the equity applicants. But then if they're going in thinking that everything is free and it's just going to be given to them, and they undercapitalize because of that, so they don't raise enough money, and then suddenly they're caught, and then they've made these deals though with these big capitalized firms, and can they just buy them out? It's going to be taken. Is it just going to be a foil to give the big players what they wanted? That's the thing.
If I had a chance to get in the Washington industry, like if there was a state program that, because like we said before, the weed sells itself, right? And this is not. I mean, as a young kid, dude, I was a pharmacist. I happened to meet an ends to a mean and help a lot of people as far as supply and demand goes.
Right.
And I wouldn't mind being a gardener if I could just have my own little garden and do a thing to sell my weed. But that did not happen here. And I mean, even if I were to give the state 10% of my ownership, I'd be willing to do that just for a business, to be my own boss.
Well, you're not going to be your own boss. That's the thing. I mean, like, you were getting partners and you were getting investors. So like when you have an investor, just like when you go down to the bank, you have somebody that you owe, and you have to make sure that they understand the operations. And that's one of the things that, people kind of gloss over, how their company is going to function. And then not only that, how much understanding and appreciation they're going to give to like how their company is supposed to be operating. And so these applications that people are going to be delivering are huge, and you should have an understanding of what that is. I mean, it takes a lot of work to review all your are the people that are applying for these licenses, will they have read their application? What do you think?
Oh, probably not. Guaranteed not.
But that's hilarious then, because these people they're going to sign it, and they're going to, I'm sure in those signatures, they're going to be like, you mean you didn't read it? And all those things that are in there, those 500 pages, those are all promises you're making to the state. And if you win, it's conditional.
Well, and that's the thing, right? This is legalization, right? You have a lawyer representation, you have rights, you have pretty much just rights. When it was medical here in Washington, like I said before, you got a job with a friend that you knew somebody, and they paid you 10, 15, 20 bucks an hour because you're good at trimming. But there's no medical, there was no overtime, there's no, there's no contract. And, as Americans, I think we live by that, right? Like, as a business, for business.
But that's it. I mean, like, if you look at America is a contract that governs itself. And that's one of the reasons why we have corporations. Again, they're more contracts that govern themselves. But most of the people aren't reading what they do. And so that becomes a big problem when your job is to know what you've represented to the state. And that is a condition of your license, so that you know what your license entails in its day-to-day operations.
So if I was to apply for this application and I wanted to get representation, what kind of lawyer would I get, being that there's so many of y'all?
I think that is a great question for our guest today, Scott.
Hi, guys.
Hey, Scott.
Thanks for joining us, man.
Happy to be on.
Cool. Can you introduce yourself a bit?
Yeah, so my name is Scott Roberts. I'm an attorney out of Detroit. I have a cannabis business law firm, Scott Roberts Law, and we help cannabis businesses here in Michigan with their applications, with their contract work, and kind of generally helping them comply with the law.
So one question that I have for you now, do your clients read their whole application? Because that was one of the things I was just asking Miggy, and I was like, I bet Scott would know that.
Some of them do, some of them don't. It kind of depends. We have certain clients that will go over every single word on an application because they want to make sure it's perfect. And then we have some clients that's just like, get it done and get the license, and then we'll figure it out from there.
Get the license and we'll figure it out from there.
Do you guys find that the internet has made it harder for your job because now everybody's a lawyer and doctor?
There's what is that old joke? There's two jobs everyone thinks they can do: being a stand-up comedian and being a lawyer. And there's a lot of free resources out there. So people a lot of times will think they know the answer to a question. And a lot of times what happens is, this is here in Michigan, it's a constantly evolving area of law, and laws the implementation of laws will change without really any notice. It just kind of MRA, which is the Michigan regulatory agency that governs marijuana. They sometimes just change their reading on things. And unless you're actively involved in it, you don't even know. So, there's a lot of information on the web, but if it's more than a year or two old, there's a good chance it's no longer up to date.
Yeah, just like yesterday, 161 new pages of federal regulations regarding what the meaning of hemp is.
Yeah, for hemp, that's funny because we were writing a lot of articles on like CBD hemp last year. And we had this thing where every time we wrote an article, a week or two later, something would happen and the article would be out of date. And that happened like a good 3 times in a row. We wrote an article and then the state of Michigan released guidance, and then that changed it. And then we wrote another article, and then all of a sudden the 2018 Farm Bill passes.
Yep.
And it just kept on happening and happening. And it just kind of reflects the fact that this is such a fast-moving area of law, whether it's hemp or cannabis.
Do you guys think this new 160 pages, which it's not official yet, right? They're still going to have an input time.
That's right.
For
the
this
drafts. Remember, they do the draft, you get the comment, they do the revisions, there's a final.
Because once it becomes final, do you think there'll be like a bottleneck? Because right now, people Wild West are just going nuts. They're growing, they're doing the extracts, they're embedding, they're selling on Amazon or wherever the fuck they sell on. Once this actual 160 pages, do you think everybody's going to stop for a second and start reviewing? Or right now, they're probably proactively going at it, aren't they? Probably just preparing their business if you're smart about it.
Oh, I told my clients to punt, and then I'm kind of glad I did, because like right now with what happened, there's some seed whose price is going to go through the roof. There's some seed whose price is going to go through the floor. Some farms are going to go bust. Some farms are going to make a great bit of coin. And so, man, I don't know. Scott, what do you think is going to happen?
Well, with the hemp market, you kind of have 2 types of players. You have the fly-by-night players, and then you have kind of more the kind of formal businesses. So I think, the more kind of businessy guys, I think they're going to finally have an advantage over the fly-by-night guys, because they're going to be the ones who actually pay attention to this and make sure they structure their businesses in a way that is compliant and works within the rules going forward. And I think the fly-by-night guys are going to, make some mistakes, and then they may get into a lot of trouble.
There's a lot of that in the cannabis industry, this fly-by-night stuff. As we were talking earlier, how people are easily offended about just like subtle things, right? Because you guys,
I can't believe you would say that, Miggy.
I know.
It's a good thing I'm sitting down.
Activists don't get offended by anything or weird at all or anything like that. But Scott, your guys' website's business first, right? Cannabis business first. It's not you were the first in cannabis business. You're just about the business of cannabis.
Right. Yeah. And we put that there because we wanted to differentiate ourselves from kind of the criminal lawyers who are working in the, cannabis business. And, we come from all kind of corporate law or real estate background. So that was kind of a way to show people that, we're business first lawyers. We know businesses and we represented businesses well before the cannabis industry, as opposed to someone who kind of comes from a criminal background and maybe doesn't know their way around a purchaser agreement or an asset purchase or something like that, compared to, say, a corporate lawyer who's been doing it all their career.
When it comes to cannabis business, would that, like we were talking earlier about the Illinois contract, would you be someone I'd want to come to then for say, hey, could you go over this contract before I get involved in it?
Yeah. I mean, contract review, drafting, negotiation, that's, a big part of almost any corporate attorney's practice. And, the way we consider ourselves, we really consider ourselves as corporate cannabis attorneys, not just cannabis attorneys, because, cannabis attorney can mean a lot of different things. There's a lot of people calling themselves cannabis attorneys, and they really are, basically cannabis DUI attorneys or cannabis possession attorneys. And that's a whole different area of law from what we do.
That's right.
If I was to start practicing that, I'm sure I'd be pretty horrible because I have no clue what I'm doing. But with the corporate stuff, that's what I've been doing the last 9 years of my life. So, I'm a lot more familiar with that and feel a lot more comfortable, working in those sort of matters.
That's what one of the things that I've kind of like noticed, and I've been a little bit surprised on, is that I haven't gotten more of the people that have been offered contracts by somebody else asking me to review it, because these people are forming these corporate unions, and each person that is getting involved to it should be individually represented so that somebody has gone through that particular contract to how their rights will be affected. And then there's the rights of the company, so each person who comprises that company can have their own lawyer so that they really understand it. And there's that, I just can't believe that more people haven't come out and been like, hey, can you read this? Somebody offered that to me. I'm not sure if that's coming in the future, but we'll see.
Yeah, you'd be surprised how few people actually do that. And, if it's someone you're, an investor, usually the investor will have their own attorney because they have money.
Right.
But, sometimes you'll have like 3 or 4 people in your office and you talk through all the issues and, you draft it for the company, but you have to make sure they know, I'm not representing you guys. I'm representing the company you just formed.
That's right. And then
important distinction.
Yeah. And I put that in the contracts, the independent counsel clause, and just like, look, guys, you're saying that you did this. You're saying that you had the opportunity to go get your own lawyer. So I don't want to hear nothing. Like, if this blows up in your face later, somebody could have explained this to you.
Yeah, I put that in my my operating agreements, where it's like everyone has been advised to seek outside counsel. And
it doesn't make any sense. All right, we're talking about a cannabis dispensary. These are $1 million operations. And aren't they?
Yeah, I mean, a lot of them are selling for $4 or $5 million.
I've seen them like going for 9-ish over in Illinois. And one of the reasons for that may be explained on this chart right here. That let me pop up real quick. You see, the number of adult use cannabis retail stores per 100,000 residents. And if I can zoom in a bit on that, is that a little bit better maybe? So you can then see it's Oregon at the top, Colorado, and then Washington State, and then Illinois at max, Nevada, California. It's too bad that they don't have Michigan's data on there.
We don't have adult use yet.
How does that work? I see people advertising that they have it. So what does that mean? And explain to us where is Michigan cannabis?
Yeah, so we have a fairly well-developed medical licensed program. And we're kind of in the process right now of transitioning a lot of that to the recreational system, which is kind of a parallel system that is very similar, but there are some differences as far as license types. So on the recreational side, they're going to start accepting state licenses in 2 days. And then that's going to be a 90-day process at least. So, and then they also have to get a municipal license or some sort of municipal approval. Most likely there may be an exception to that. We'll see. So, for the rec side, we're probably not going to start seeing recreational dispensaries. My guess would be maybe March or April of next year. I mean, technically they could be open by January, February. I just don't see it happening because it never really happens as quickly as people originally want it to or think it will. It seems like there's always delays, whenever there's.
So they're all on burn rate right now. Like they're all just burning through cash right now in Michigan.
Well, we have a very robust medical program with hundreds of thousands of patients. We have the most robust medical program pretty much in the entire country. So
they can sell.
That really kind of feeds most of the Michigan market. We probably have a medical program, and I'm maybe making this up, but our utilization on medical is probably close to some states' utilization on rec, where California is like the actual legal market is actually a minority share of the actual total market.
Right.
But in Michigan, because we have more of a developed medical program, and it's also very easy to get a medical card, that you have hundreds of thousands of people with medical cards compared to a state like Illinois, where I think you guys have like 70,000.
It's starting to explode now that they've opened up the amount of conditions. But I wanted to ask is the adult use license holders that are getting ready to open in March, can they currently sell in the medical channels, or does their license not allow for that?
Well, no one has an adult use license. I'll just be very clear on that. There is no one here in the state of Michigan with an adult use license, but there are a lot of people with medical licenses. And, we have a rule with the medical and rec kind of similar to Colorado, where you can kind of have both in the same facility. So what you're seeing is we have all these medical dispensaries, growers, processors, and they're all going to be transitioning over to rec. So they have their medical license, but no one has a rec license yet in Michigan. As a matter of fact, November 1st is they're going to start accepting applications. So no one's even applied for one yet.
So with those applications, they're not going to automatically just say, okay, if you're medical, now you can turn over. So that's what Oregon did. They said, okay, if you're medical, now you can be recreational. Are they going to prioritize and say, okay, since you've been in the industry, since you've been doing this for a while?
Yes. So, the recreational applications, you can kind of divide them into two groups. One of them is the one where you actually have to first be in the medical program first. So if you're a larger grower, what we call processors, I think you call them infusers in Illinois.
No.
No, I made that up.
Processors may one day be infusers, but infusers simply buy the extract and put it into gummies and something. That's it. Only the growers or the craft growers can take the flower and put it into rosin or something.
Okay. And then, also the provisioning centers, which is what we call dispensaries. For all those license types, you have to first have the medical license, and then you still have to apply for rec, but it's probably a relatively easy process, and you just have to make sure your municipality is on board with it. And then you can get the rec license. But then there's a group of licenses where you don't have to first have the medical license because those medical licenses didn't exist. The big one being the micro business license, but also what we call the designated consumption license, which is kind of like a cannabis lounge or a coffee shop.
Ooh, that'd be exciting.
When do those come out? And then who's regulating that? Is that the state or is that the municipality?
It's mostly regulated by the state, but the municipality does have to approve kind of the specific locations with respect to like the events and the lounges.
I think your guys in Michigan, and it'd be a surprise to most, but has a great and old cannabis culture, which I think helped your guys' market. Yeah, Hash Bash, John Sinclair, who has a cafe still there now.
And is he like on the Hash Bash float? Is there a parade for Hash Bash yet?
I haven't been to Hash Bash in a while. I used to go when I was a lot younger, but it's been a while since I've been to Hash Bash.
So you are a consumer. Are you a patient as well?
Yes, I am a patient.
Right on. What are you treating it for?
Putting me on the spot.
Just put harshing.
Or a
mellow.
Health reason. How about
that?
Yeah. I like my thing's a back. I have a documented bad back, and so clearly, I think it's a shame you can't just put case of the Mondays for your reason to have
case of the Mondays. Yeah.
Hey, that's the thing.
You have to have you can use pain and you can use intermittent pain, and that's kind of the big grab bag that everyone.
Can you use depression? Is depression yet a recognized thing, or do you still have to go to a Zoloft then? Because like once weed starts taking off Zoloft, goodbye pharmaceutical industry.
No, you can't do depression or insomnia, which is
which is ridiculous. CBN, right?
Uses I use it for. I just I have another approved medical use, but insomnia is actually, and I think that's the best use for it, at least for me.
Well, even PTSD is not recognized in all states, so there's a various on each state what they allow for medical.
Yep. But I think that it's interesting that you just described something fundamentally different than Illinois' law. So that's another wonderful Captain Cuckoo Bananas of this, because when I'm talking to some of my possible clients, when I'm just consulting with somebody first before I've seen if I can figure out how to work with them as their lawyer, a lot of them will ask, well, I want to get in the industry. And I will say, all right, well, maybe Illinois is not the state for you because of these barriers to entry. Maybe you should try Michigan. What's your likelihood of success if you want to get into the cannabis industry and you're in Michigan?
I mean, if you have the money, you can do it. We don't limit it the way Illinois limits it, where we're only issuing a certain amount of state.
What's adequately capitalized for the money? Let's talk about this money.
Yeah, it's depending on your situation and depending on the license type, you're going to need some money or a lot of money. And in Michigan, like the big cost is usually the real estate, because we kind of have things a little different in that it's pretty limited on the municipal level. So there's a set amount of property that would qualify for a cannabis use. And sometimes, a municipality will limit the amount of licenses for a specific use in that municipality. So that actually kind of creates a property bottleneck. And we're seeing these properties, the price go through the roof. And that is one of the big costs people have to face is properties. And, we're working with some people now with some leasing opportunities, because we've kind of seen this. This is a huge barrier to entry and doesn't necessarily have to be. But, there's not a lot of people leasing, because they're afraid if they lease to a cannabis use, their mortgage is going to get called, which a lot of them
What do you mean by their mortgage is going to get called?
So, a lot of these mortgages will say, you have to have, you have to be in compliance with state and federal law.
Right.
Like we all know marijuana.
Well, think about it. Where's that money for those mortgages usually coming from? Especially for residents.
Yeah, like FHA and all those.
FHA, it's federal money. You're going to take Uncle Sugar's money. You're going to play by his rules. And
that happened here in Washington, though. Like that's how they went after people. Like in the early days of medical, landlords would get letters. You need to get this person out or close that business under your rooftop, or else we're going to come after you. And I saw many people had to close doors. They're like, yeah, the lawyer just said, or the landlord said he got a letter, and we can't do any more business. It's a very scary and gray area for this whole. For you guys in Michigan, Scott, do they break up the market as far as here in Washington? You can't be a grower and own the store at the same time when it comes to the recreational market. Are they doing something like that there too?
No, not really. You can be vertically integrated here in Michigan. Nice. So you can have a grower, a processor, a dispensary, all together. I would probably advise maybe not holding all three types in the same entity for some legal reasons, but you can basically have them all together and be completely vertically integrated. You can't, though, if you held any of those licenses, also hold a testing license, which is the license that kind of tests all the products and makes sure it passes our kind of safety testing measures. And then the transport license, which is, how you got to get product from point A to point B.
Do you affiliate all these entities then when you said that? So like when you're going to be advising a vertical integration of a client over time, for example, would you say we should start a new corporation or a new LLC for this particular venture?
A lot of times we do. And a lot of it is just kind of the, not putting all your eggs in one basket. As an attorney, that's usually something you want to advise your client. With each new entity, you got to pay a $6,000 application fee. So, sometimes people don't want to pay that. But at the very least, we always tell people to make sure that their dispensary is in a separate entity, and that entity is separate from the cultivation and the processing. And there's a lot of kind of accounting and tax reasons for that.
Oh, because of the processing and the growing, right? Then because you get into the two different types of tax treatments depending on what type of cash flow it came from.
Yeah, usually it's, it's okay to put the cultivation and the processing together, but the dispensaries you want to keep completely separate. And a lot of times we'll have them have different tax statuses. A lot of times we'll have the dispensaries have a C Corp tax status, and then the grow and the processes have a S Corp.
Do you do that out of also protections in case, say, the feds get a hair up their ass and start raiding farms or something one day? Would that help them separate like the storefront versus the grow?
Not sure I understand the question.
So like here in Washington, we still have people being raided. Even though we're a recreational legal state, some people have too many plants or whatever. But say if I was a business and they took my plants and I have a storefront, because when I was medical, it used to be vertically integrated. That was all in one. And some of those people got raided, and then so they had no products, for however long, but they kept the storefront. Is that like a protection there too when you keep the two different LLCs? Or I guess.
Yeah. So, and one of the other reasons we do it is because if you have a problem with one of your licenses, you don't want it to kind of infect your other licenses. So if you hold all those licenses kind of together in one company, and there's an action for, failing to comply with the law against that one license, then, all your licenses held by that company kind of get put at risk. So if you have the licenses in different entities, then
that's their property, not yours. Because corporations own their own property. So this is their right. It's not their right. And then they just have some affiliation and overlapping in ownership.
Yeah. Overlapping, or sometimes it's almost, 1-to-1. It's the exact same. It's just, they keep.
Well, perhaps like, with the craft grows, I could see the craft grows. We kick some equity kickers to get some of the best talent to be your master grower, right? So it's like, all right, well, because a master grower doesn't need to be on a dispensary application. That's cool.
I just, as we were talking earlier, and how people just don't understand the need for a cannabis lawyer. A lot of times it's hard for them to comprehend that, we're at a state now. It's like if I went to a liquor store, I'd probably have a lawyer, represent me, or if I ran a toy store.
You run a business. Business is complicated. You shouldn't. People go to school and major in the stuff. It's a thing. Yeah.
It's a highly regulated industry. And if you're in a highly regulated industry, you're either going to need to be the expert yourself. And then, you need to make sure you put 10, 20 hours a week aside to, stay up to date on everything, which a lot of people don't want to do. Or you need to hire someone who will. That's where we come in. And, my background, a lot of what I was doing before cannabis business was corporate healthcare, where it's the same sort of thing, where it's a very highly regulated industry.
It's the same, but it's a different, because in healthcare, right, the feds are on top. Here, the state's on the top. So, healthcare is extremely overregulated or heavily regulated, but a lot of the laws arise from a federal guidance as opposed to a federal prohibition.
Yeah. So you're right in that, with healthcare, it was all about, a few kind of federal statutes like the anti-kickback act and Stark and all that fun stuff. And with cannabis, it's almost like we almost ignore federal law. We don't, but in a way we do.
Yeah, you ignore it to the extent, like with the banking, you're like, don't ignore this particular aspect. So your bank should set those SARs and you should operate like in ways that you are going to be compliant in state law. So you're not, asking for federal intervention, but the only thing you're really trying to do is just not poke the beast.
Yeah, because there's really no, federal cannabis laws we worry about too much. There's the Controlled Substances Act, but that kind of is what it is. And at least with the medical, there's some protections with like the Aurora Baca-Farr amendment. But, with rec, we're going off some rescinded guidance letters. And that's, so we don't really have a lot of protection on the federal level, but we just kind of do what we can and, know that with the current political climate, we don't think we're going to get into trouble as long as we're state law compliant.
Right.
Yeah, that's a big one, state law. In the business side of things, Tom, you'll laugh at my favorite case I like to point out with Paul Stanford.
Mm-hmm.
Are you familiar with that one, Scott?
I'm very bad with case names. Though
Oh,
sometimes when you start explaining the case, I'll be like, oh, yeah, that one.
Yeah, well, this gentleman, he owned THCF clinics in Oregon, and he made a lot of money at the clinics. I mean, this is kind of an auxiliary part of cannabis, right? They were getting prescriptions for cannabis use. He made a big network, made a lot of money, but then he signed a contract with an Israeli company based out of Canada. They took over his company. They rid him off out of the company. He's no longer allowed to, he doesn't make any revenue from it. And they almost sued him on using his own name because he's a pretty large cannabis activist in Oregon. My thinking is if he had a better lawyer to go over the contract that in the business wise, I mean, the protections that that's what you guys offer is protections with any sort of negotiation contract.
Yeah. I mean, with, contracts, one of the jobs is making sure there's no surprises.
Right.
And then, another part of it is kind of thinking through all the different scenarios of how this could play out and making sure we're protected with respect to each scenario. Because a lot of these contracts will have buyout clauses. And a lot of times, we can't get out of them. And it's just the investor wants a buyout clause or the company wants a buyout clause. And that's just non-negotiable. But there's still ways to kind of soften the impact and, protect people, especially, in a situation where, he can't even use his name, which I would assume arise because he used his name in the practice and he signed over all the IP. But even then, you probably want a carve out so you can use your own name. And it may seem silly to think about, but a lot of, what we do is looking at these weird worst case scenarios and making sure if the worst happens, we're not, out of luck.
What do you see in like the cannabis industry that is the most pressing contract issue that your clients aren't addressing?
The most pressing contract issue. That's a tough question.
Or what's one of the things you often fix? Like what's one of the things they typically overlook?
I can tell you on the real estate, generally it's, making sure we're protected if we don't get a license. Because a lot of how we do it is, some people think, oh, I got to buy a property and then apply for a municipal license.
Mm-hmm.
And that's just kind of like, it kind of makes sense when you think about it, but that's also not how we do it and not how we'd ever advise anyone to do it. We put the property under contract, then apply, and then if we get the license, then we close. And that's something where people new to the industry, they're just like, I don't think you can do that. And it's like, no, you can do that. We do that like every single week. And that's one of those things where, maybe people don't think of it, but
I don't think they need to do it. Do they need to do that? Because, for example, in Illinois, a dispensary license, you have 6 months to get that contract for the real estate. Even the signed lease, let's say you're not going to buy the real estate, but it's different for the cultivation. Does Michigan require you to have a physical location for your dispensary in your application?
So there's kind of 3 parts to the application, and 2 of them you do. So there's 2 parts to the state application, and then more important than that, because it's generally the more limiting factor, is the municipal application. And the municipalities almost across the board require you to have a specific property, but that doesn't necessarily mean you have to buy it. So, we generally just put it under contract, make the PA contingent upon getting the license. And then when we get the license, we close on it. And if we don't, maybe we're out some, deposit money, but at least we're not stuck with the property fully paid off that we have no idea what to do with.
This for both of you guys. I know it's been an issue in California and it's been a big issue out here in Washington about moratoriums. Is there anything that you guys are doing for protections on that?
Our industry's too new, so there's no moratorium.
Well, I
But,
said they're going to come though. If say like you get your license,
like in
to
10
play-
years, maybe, like, if they have 1,000 different licenses in the state and they just aren't issuing any more, is that what you mean by moratorium?
Well, here we have cities. I know I've seen it in California too, where the city of, say, Seattle says, you know what, we're tired of weed. We're gonna have a moratorium. City council votes, no more weed shops in our area, and then you've already rented a property that you've already put listed on your license application that you're going to use, and now you can't do business out of there because there's a moratorium.
We do have moratoriums on the municipal level, quite a bit, but then that kind of goes back to that structure I was talking about before, where if you're mid-application and they, say we're not issuing any more, at least in that case, you're not stuck with that property.
Mm-hmm.
Because, there are moratoriums. The city I live in right now, Royal Oak, there's currently a moratorium. It's probably going to be lifted pretty soon because they did it to give themselves time to figure things out before they kind of pass a municipal ordinance on marijuana.
Mm-hmm.
But, there's places like Detroit where they say, we're capping it at 75 standalone provisioning centers. And if you're not one of those 75, you can't get one.
Yeah. Illinois is that. If you're not one of these, you don't get it. But then the municipalities, we don't have that moratorium. We have opt-in, opt-out. So more like a binary yes, no. And some municipalities are like, not in our backyard, and they aren't passing it. But other ones, my city said, sure, we will, maximum tax.
Oh.
Yeah, I did notice that in the Illinois statute, you guys have a municipal tax potentially on top of, the already, I would say, somewhat burdensome tax scheme.
$100 eighths is what I'm envisioning. I mean,
I was thinking 90, but you might be right.
I mean, we'll see. But $100 an eighth. I mean, thinking back to college 20 years ago, the highest price I paid for an eighth was $60. And yeah, it was dank. It might have been like bubble gum or something. But now I'm paying $59 and the weed is way better. So no, there hasn't been any weed inflation yet.
No, in Michigan, I feel like there's been some deflation. Since we passed our first medical law in like 2008, 2009, all of a sudden you saw the quality go up and the prices drop, which is
nice.
A good thing.
Yeah. Mm-hmm. So you're a Detroiter, Scott? Is that where you're from? Yeah,
the Detroit area. I grew up here, and my office is downtown Detroit, and then I live in Metro Detroit.
I just think that helps with your your ability to stay more connected with the laws in your state. Being from that area, the networks. Yeah.
Like if I'm not practicing in Michigan, I know nothing of their medical marijuana law or their adult use legislative fabric. And then like talking to Scott, I'm like, nope, they do not do that here. That's interesting. Yeah.
Well, you're just starting to expand to Florida too now. So, I mean, I can imagine each time there's a different set of rules you got to learn, a different parameters.
Yeah. I mean, not Florida, but another state that I think Tom and I agreed not to talk about. But yeah, I mean, it's kind of overwhelming when you're in a new state and all of a sudden, you have a crash course and it's 600 pages of, statutes that you're going to have to really know.
Right.
And that's, that can be, very burdensome and will make for some really boring weekends.
Yeah.
Oh, come on. I mean, think about drafting all those corporate documents and understanding how they all fit together and work. Those can be some very boring weekends also.
Yeah. I mean, I don't know. I don't think there's anything more boring than reading an incredibly dry 600-page statute. I feel like that's the worst.
That was pretty bad.
Some of those more complex agreements, they kind of get interesting because they're also intertwined with each other. And,
right.
There's more kind of hands-onness to it. But when it's just kind of dry reading, it just puts me to sleep.
So, Scott, do you help with applications? Do you help with that process at all?
Yeah. Our firm does quite a bit on the state and municipal level here in Michigan. We've had a lot of success on both levels. The state level is really not all that tough.
So you don't have a 60-page security section like Illinois?
Well, we've done some municipal applications that are kind of merit-based the way Illinois is, and we've had 20-page security sections with and then like attachments for spec sheets of the different security equipment we're going to use. But it kind of just depends, because if it's not a merit-based application and we're not getting scored on it and ranked on it, then generally we're not going to provide all that level of detail, because each thing we provide is a commitment we make.
That's right.
And if we can get away with not making commitments,
You didn't
we're not going
promise
to make
nothing.
commitments.
Yeah.
There's, the state part 2, that's kind of the second step of the state. And, they ask you for a record keeping plan, a security plan, all these plans. And, we've seen some other attorneys' plans and they're pretty thick. And we're just like, why are you doing this? Because when we do them, it's like almost a game for us, where we try to commit to as little as possible while still getting approved, knowing that if we need to tweak it, they'll always allow us to tweak it. But we're not going to go ahead and submit a 10-page security plan, because we're inevitably going to be committing ourselves to things we may not want to do down the line.
Oh, that is such a luxury, because if I would, the advice that you give to a client as to whether or not they're in Royal Oak or in Peoria, Illinois, is fundamentally different, because I'd say you have to go over and above, because if that other guy makes that promise, that's a higher quality application. You're going to get a higher score. You're out. And so you can't under promise like that and then be held to a lower standard. But that's very important. And the distinction is the same that you made there. So in Michigan, it's still conditional promises on the application. So your application becomes a governing document for your business.
Yeah, and the state and the municipal level. I think the municipal level, that's where, we have a lot of kind of merit-based municipalities. And then it's kind of like Illinois, where we almost need to commit ourselves to a bunch of things so we can get enough points to actually get one of these licenses. It's just that we also have to be careful that we got to commit ourselves to things that we're actually able to do.
That's funny that comparison as the legality goes in tech, because that's what I do. I work in tech. When you get accredited as a lab, there's a big checklist. And if you say yes to any part of that checklist, you have to prove that you can do that. You have to perform that function. So if you just say no to a lot of stuff and just perform the bare minimum, you're good to go. You get your certification, your A2LA accreditation, and now you're an official lab.
It really depends on the situation. We, unless we need to, we'll avoid making those commitments, but sometimes we need to.
Yeah, it makes solid sense.
Corporate flexibility, it's what it's about, and protection.
Well, that's the important part about the cannabis business lawyer side of things. People might gaff at it. So what was the last thing that we're talking about? What was the last podcast, I think, where I was talking about how lawyers and policymakers are now the rock stars of cannabis, because it's all shit that nobody else wants to do.
Yeah. That's fine. I'll be over here smoking this weed, listening to that music. You good luck on that 600 pages of statute. God bless you, sir.
Yeah, I mean,
you'll still want it for free.
I mean, we have a lot of clients who's like, I wish you had my job. I had your job. And I was like, do you? I see what you do. And you know what I do. Which one's more fun?
Yeah.
Well, Scott, thank you so much for joining us. Where can we find you, follow you, check out Scott Roberts Law?
Yeah. So, www.scottrobertslaw.com. Our office number is 248-234-4060. And feel free to check us out online. And then also, if you're in Michigan or looking to start a small Michigan business and get into the cannabis industry, we encourage people to check out marijuanamicrobusinesses.com, which is a partnership I formed with some other service providers to focus on kind of the smaller, newer entrants to the market.
Nice.
Awesome. And Miggy, where can we find you?
I'll be here next Wednesday.
All right. And Tom?
Next week, I'm going to go to Bob Karp's. He's giving with Reliance Compliance, they're giving a seminar, and they're going to go over the Illinois application or what they believe the Illinois application is going to entail. So I'm going to sit in on that and then use that knowledge to help my clients get their applications done correctly. And so I'll probably be remote next week, but we were almost remote today with this internet surge we had.
Awesome.
Yep.
Well, guys, thanks for tuning in. As always, like and subscribe for more cannabis legalization news. Tune in next Wednesday.
Oh.